Welcome, everyone. This is the Domain Name Law Show. My name's Todd Ryan. I have two co-hosts along with myself. That would be Jeffrey Neuman and David Michaels. We're here every Tuesday. That's noon Pacific, 3 p.m. Eastern, for the Domain Name Law Show, where we cover domain name legal news and we review recent UDRP decisions. Sometimes they could be old. First, I'd like to say hi to my co-host. Hey, Jeff. How's everything going with you today?
Hey, good. I just saw an email from you from earlier, which I had not seen previously. So we'll catch up after the show on that. Um, but yeah, it's good. It's very freaking hot. In the DC area, it is 100 degrees today, which is a lot. And so I've been staying indoors, but tomorrow I travel to Phoenix for a court hearing on Thursday.
Well, we'll look forward to hearing about that because I think we know a little bit what it is. But yeah, so it's weird. You're going to Phoenix to cool off.
Yeah, no, it's supposed to be 103, so yeah, it's not good anywhere.
Oh, so I didn't know it was hot there. I know on the East Coast it's getting warm. Hey, David, did the heat come up there? How you doing? And then did the heat come up in Toronto?
Oh yeah, it's been a steaming sauna since Sunday. Um, yeah, it felt like I was camping out in Death Valley. That's how bad it was. It still is.
Yep, I know
It's in the
you've
high
been.
90s Fahrenheit, 35 Celsius with high humidity. So it's a different heat than you would get in California or Arizona.
Yeah, I mean it's wonderful here. I gotta say it's about 75. But even when it's 80, 85 it highs these last few days, in the shade in California is beautiful. Even 85 is okay, but I mean in the Midwest sometimes, definitely in Florida and Texas, in the shade it just doesn't matter. It's still miserable. That's okay. So we pay for it out here. It's expensive. Hey, while we have a friend that joined us from down under on stage, hey Nathan, how is the weather down or down there, but in Australia today? I know it's early morning for you.
Let me just have let me have a look. Here in Melbourne, it's because it's 5 a.m. That's not the track. What's the weather? Weather. It is 9.6 degrees Celsius. Yeah, cold and really windy.
With all of us, we're like, okay, yeah, 9.6 Celsius. Yeah,
I,
that's
I
like,
was just I was just being jealous listening to you guys complain about how hot it is, and I just booked my flight for the London Domain Summit, and I'm looking forward to getting on the road again in the next few months to get some heat, before it starts getting hot here again.
right. It's just getting into winter months there. Okay, so we have a big show today, but I wanted to say it's been nice, seeing Nathan, even Courtney jumped on stage earlier when we were playing the song. It's nice to see old friends. I see a lot of friends here. Anyway, thanks for joining us. We got a bunch to
My
cover today, but
pleasure.
Nathan, you're repping. You got a couple new domain names. I saw that you posted oi.com. I guess that's oi. That's what I'm gonna say. And then
Correct. Yep.
successful.com. So those are when you say you're repping those now, are those new customers or those portfolios that you've had, but finally they're making the domain for sale? Tell us briefly about how
So,
you start
so
representing these.
this client's been a long-term above client, with a lot of other portfolios. Um, and obviously, I've been working with him over the last couple of years selling other names. And I've been working on him for the last 2 years to get him to change the name servers and let me go to work. So I've been lucky enough to get one offer in the last 24 hours on it. It wouldn't get the deal done, but it was a great starting point. So yeah, super excited. I've also got brokered.com, which is nice as well,
Well,
that I've just added.
thanks for joining us. I want to ask you one question before we get going for today, and that is, how do you feel about? I mean, you're doing it. Brokers making the public aware that it's a name for sale, like posting on X. Some people, some brokers act like it's not the place to do it. But I know I'm seeing more brokers from Grit to yourself, really to media options. Everybody's saying, "Hey, by the way, we're representing this name." How not only is that effective, but how smart? Why now do you feel it is important to, post names that you represent, make the general public aware that these names are available to, to inquire about, to purchase?
Well, it's so the reason why I post on sorry, not LinkedIn, on X, it's a captive audience. It's of all my followers, that 99% of them are domain investors. So I like to the big thing for me is education. So I like to share what I'm doing. I like to share my opinion on things, whether I'm right, wrong, or otherwise. I like to help people, and it's just one of these things that it's letting people know, creating awareness, creating a buzz, because you never know who your post is going to appear in front of.
I like to help people. Um, I don't know if that was Australian accent or English, but I'm gonna start doing this anyway. You're
Ah,
sincere. I know you're sincere, and you do like to help people. And no, I just wanted to hear from you, Nathan, that it is you don't know who you're going to reach out there, and it certainly doesn't mean someone's desperate to say, "Hey, did you know this name is available?" But you get some people from some schools that believe, yeah, you don't need to do that. I mean, it just doesn't make sense to me that I mean, after there's still people that don't know you can even buy domains on the aftermarket. They think they're registered. Oh, that's done. No, of course it's not. But so no, I like seeing that some of the names that you post, and I think it can certainly get folks in our space, to say, hey, I mean, we have a lot of people that come to us saying, I'm looking for these types of names, especially a two-letter, very, very unique, two letters with two vowels, so rare that some people, companies, and that's, I mean, a lot of companies would just dream to own a two-letter, and OI
yeah.
with the I on the second, can stand for incorporated, so it can really almost be like a single letter OI. All right,
Mm.
we're
Well,
pumping
the
you up.
beautiful thing is, like, so I shared the post on, obviously, LinkedIn and X. Now, I'll talk about reach just very quickly because I know the show's going to go on. Like, since I released that post on both LinkedIn and X, I think my reach for this particular post is about 15 to 16,000 so far, and it's been less than 24 hours.
Jeez. No, it's good to hear. No, and we look forward when we come back. And of course, Nathan, it's matter of fact, it's a little too early for you because it's 3 in the morning when we start the DNX show, which is more appropriate for domain investing and diving deep. Certainly gonna we had a pretty exciting show this Thursday, DNX show, about recent post that Darpin made too about .ai extension and how he feels about it, and everyone has an opinion on that. But thanks for sticking around. We have time at the end. We're going to blow through our cases, I think, pretty quickly today. Maybe even talk a little domain investing here at the end. So thanks for joining us, and thanks everyone for being here. Um, Good to see Larry. I wanted to say I heard Larry talk LS Love the other day on a show. He never comes up on stage anymore to say anything, but it was always good to hear from him. And Larry, I just want to say, when you're around, whether you're on stage or not, it's always good to have Larry there. It makes me feel good. It's like, I don't want to say safe spot with Larry around, but no, it's always good to have Larry, and it's good to hear from you the other day, Larry. Glad to hear you making anyway. He was saying he's having an upcoming birthday. I'm not going to say his age. He doesn't care, but he's basically saying we need to get on the stick and sell these names. A lot of us aren't going to be handing them off to people who don't want them anyway, and then can't take them with you. So always pressed to sell these names. All right, if you want to follow along, you can check us out, dnlshow.com/outline. And today I had the first story, and it was ridiculous that I put it on the outline because I had, let me look at it, it said .ai extension, .ai to begin trading on Nasdaq stock market. Okay, if you go to the story, it's not the .ai extension, it's not Anguilla partnered with some American company, which we know, I guess, it's public. Is it public? Who's the registry, Jeff, that does the .ai extension now? Is it called Public Registry. What is the name of it?
I think Identity
Oh,
Digital is the
Identity
one that,
Digital. Yeah.
yeah, I think they're the ones that manage the back end. But yeah, when I read that, of course, you first think of we being in the industry first think of the registry, but it's not. It's a company that does artificial intelligence that happened to name themselves .ai, which I think is kind of weird. But
Yeah, super confusing. Okay, I was going to say, yeah. So Public Registry handles the .org, and then it's Identity Digital that took over, right, from Vince
yeah, well, and
Cable.
to make things more confusing, Identity Digital does the back end for .org. So Public Interest Registry is the front end, but the technical services are actually done by Identity Digital.
Yeah, I mean, you teach me stuff all the time. I mean, I didn't even know. So they're the front end. It doesn't even. I mean, I'm thinking, what does that mean for a registry? Meaning, okay, so they basically own it, and just like, I mean, I does make sense to me, but I'm thinking they're not, even though they're the front end of the registry, they're still not consumer facing because they still do business through the registrars. So it's weird that, I mean, I see now that their space is really ownership, front end of the
Yeah,
registry, making
and they
those
have that.
decisions.
They're the ones with the contract with ICANN, the Public Interest Registry. They get the lion's share of the money, and most of what Public Interest Registry (PIR) does is, their mission to, um, spend their money for good causes and good works. So they do a lot. In fact, the technical players get the least amount from the registrations.
Yeah, and there was some resistance with PIR getting, basically being able to purchase the .org, or right, and now there's really, that's sort of just been forgotten, right? So there was resistance at first that.
Well, no, there was resistance for PIR to sell. The Public Interest Registry is a nonprofit. There was resistance for Public Interest Registry to sell the front end to a PE firm because that would be for profit. And so there was a whole bunch of issues with that. And in theory, once that other firm owns .org, or if that would have went through, they could have farmed out the back end services to someone else, or whoever they wanted. They could have built it themselves. So yeah, there was a lot of concern, but mostly because .org was selling it to a for-profit entity.
Okay, so getting back to the news story that I put on our outline about .ai is going to be public, basically going public on Nasdaq. Right, Jeff mentioned it. It wasn't .ai, the registry, or anything connected to Anguilla or Identity Digital, completely separate company. David, how confusing is this? .ai. Of course, I guess they can do it, but um, when you saw this article, what did you think? Todd just put up something he
I was
doesn't want
confused.
to. Yeah.
I was like, what's going on here? Did they decide to go public? How can a country do that?
The ironic thing is that the country can't have trademark rights, or Identity Digital can't have trademark rights in .ai as a top-level domain, but there's nothing preventing these guys from having .ai as their brand for a non-top-level domain. So um, it's interesting. It is confusing, and people in the industry would get confused, but there's no cause of action to go after this company because .ai for a top-level domain cannot be trademarked.
No, I mean, I
Isn't
wonder.
there a term
Yeah.
called confusingly similar?
Yes, but you have to have trademark rights in order to go
No,
after
I was
someone.
being facetious.
Yeah,
I was
yeah.
being,
Oh,
yeah,
yeah.
yeah.
So, but it's funny, right? Because it definitely, to us, it caused us to kind of do a double take. But once you read it, it's what they call initial interest confusion, meaning that at first you kind of look at it and get confused, but once you look at the company and what it does, you realize, okay, that's not the registry. And so,
Let me just say, yeah, he's skating on thin ice, being facetious, just chiming in like that. Hey, what was I gonna say? Oh, yeah, Jeff. If somebody said, you know what, I'm .com car sales. I mean, I can't imagine VeriSign being mad, no matter if you're in a completely separate category. I go by .com. I mean, and it would be weird, but I totally understand what you're saying, and and if the crowd, I'm sure they do too. But just saying, yeah, we know you can't trademark an extension, so Anguilla, but even VeriSign, or they sell this product, but you can't trademark .net. But yet a company can say, I'm .net, I sell tennis equipment, and we go by .net, and you could apply, and I mean, I don't see why that wouldn't be approved. I mean, if you got all your paperwork straight, it's solid. But David, any thoughts on that? I mean, that is pretty interesting, though. I can't register an extension as a trademark, but yet you can do this with just putting dot in front of the
well, and
extension name.
also like it happens, you kind of come across things like what Booking.com or Booking uses. Their slogan is Booking.yeah or YEAH. Um, it looks like .yeah is a TLD. It's not, but that's their trademark. Um, I think there's one too, like U.S. Foods has something like a .food or something in their trademark, but they don't own .food, so it is a little weird.
Yeah, there's a precedent with this. Is Microsoft owned .NET for its software operating, like, was it an operating system? No, not an operating system. It's just some sort of
Oh yeah, it's a protocol.
software
Yeah.
to protocol. Yeah.
Right. Well, yeah, maybe next round. We haven't had anybody inquire with us about getting yeah, but you
Well,
heard.
they had started adopting that saying before the last round, so I thought, oh, okay, they're gonna apply for it. But nope, they didn't. There was another one. Sony had one too. I can't remember what it was. Maybe it was something like .life or Sony.life or something like that, and they didn't apply for it.
Well, we have a couple of UDRPs in our news that we're going to talk about that we're not going to analyze as much as we do with our cases that we review. So, but one of the cases in the news that probably would have been worthwhile talking about, but we can't talk about them all, is ignis.com. So it's ignis.com, a 5-letter.com. And this was basically this, I think that was the Colombian company. Yeah, they were on no. The Colombian company was the next one, Water Timer. But this was a company that was, where were they located? Let me see real fast.
Spain. Their domain name is ignis.es. They're a solar power company. They install solar power panels around the world, mostly in Europe and Asia. But they're a new company.
Right.
And ignis is the Latin term for fire. And how can they claim to own the Latin term when it's being used by hundreds of other companies? From Suzuki for their vehicles to an Italian company for something else, an oil company in Norway. It's commonly used.
Well, thanks, David. What was interesting about this case is, so this Spanish company files this UDRP against this domain owner who responds by saying, hey, we do have rights to this because it's a Latin term, Latin word for fire. And there was a 3-member panel, and one of the members on there, Gerald Levine, said, yeah, even though it's not an English dictionary word, it's no less of a word. So all 3 panelists agreed that this complaint should be denied, but Jerry was the one panelist who dissented, saying he thought there should have been an RDNH ruled, which it wasn't, because the other 2 panelists said, no, this complainant really didn't win their case, didn't have a great case. Maybe they were, um, you know, overreaching, but it wasn't so, I guess, I don't know, egregious or such an abuse of the system to rule an RDNH. And Jerry said, well, that's the exact reason why, you're saying they're overreaching. This is an exact reason why it should be an RDNH. But I wanted to bring up, in this case, Brand Bucket had reached out on behalf of the domain owner, contacting this trademark owner and said, "Hey, you want to buy the name for $1 million?" So that's really what instigated this domain dispute. Meaning, okay, so this company that this guy owns, Ignis.com, puts it on a platform like Brand Bucket. I don't know if he said, "Hey, go ahead and outbound my name," or Brand Bucket I didn't know they outbounded him anyway. So the some of the comments were from other attorneys and panelists saying, this is when you need to be careful when you're dealing with a marketplace. Read their terms of service. If you're allowing them to outbound your name, just beware that even with a generic name or something like this, like meaning fire, it could still spark a complaint by someone they outbound to. So did either of you guys, what thoughts do you have about a platform outbounding your name and then you get stuck with the UDRP or having to answer?
So I know that Adam set up a seller affiliate deal where certain sellers can, like, not domain owners, but just sellers, domain sellers, who are certified by Adam, can go ahead and take names from the platform and outbound them. And you have to abide by certain rules. I didn't know that Brand Bucket does anything similar. I see this name parked at Brand Bucket for $891,000. So it says it's here exclusively at Brand Bucket. So does Margot actually do the outbounding? I don't know. Or does she have a public program? I haven't seen that before.
Well, it's a good question for Nathan, right? I mean, as a broker, what kind of actions do you take to make sure, or to try to stay um, um, to try to stay away from getting your client in trouble with a trademark owner?
Well, one of the first things that I do before actually going, if I'm reaching out to a potential end user or even the trademark owner, I look to see what trademarks are out there. Because that then gives me the information I need to be careful, right? So because it's very easy for a trademark owner, if you send them an email, they say, well, they're targeting me, right? And that's cause for they might think to lodge a UDRP. I had a similar instance recently where I had a name which was like it was a letter, a full stop, and then the term motor.com.au. Now, they were i-motor.com, PTY and they had i-motor.com.au. My client had imotor.com.au. Now, they come to us wanting to buy the domain and got a bit narky. And then I obviously, because the guy was reasonable and, he wasn't aggressive, as sometimes people get, I actually worked with him and explained the trademark process, what happens, what you've got to prove. And, I said, if you want to spend 8 to 10 grand going down that route, that's fine. I'm almost positive that you're going to lose and then you will never get the name because my client won't like it. But if you work with me, I'm sure we can come to, come to a reasonable outcome. And we did. They were really happy and my client was happy. And it didn't cost them anywhere near 10,000. So everyone walked away happy.
You're right. If you can have a conversation with them, if you open communication and you've built some rapport with them, like you did in this case, that's really what the attorneys are going to do anyway, is say, hey, before we get into a trial, before we get into a case, here's what you can expect. And I mean, it really does make sense to do that. And I guess I'm looking at some other cases that.
So Brand Bucket does
Well,
have sales positions open. They're looking for outbound sales representatives. They're in-house but remote, full-time. So I guess it's partially commission for the base.
it's also interesting to note. So I did a little research on these panelists, the other panelists, and um, the Braun, Linda Braun, I think, she's done 600 or so cases solo, and only in two cases, or wait, I think it was two cases that she denied uh, the claim, and she's never found reverse domain name hijacking.
Wow, somebody actually worse than.
Yep.
Wow.
And but Evan Brown has found. I'm just looking now. He's very rare, but he has found reverse domain name hijacking. I think it was only in his last case, actually. Alumni Ventures. Um, he found RDNH, but I don't think he's ever found that in any other case. So always interesting to note that. But Linda Braun has never.
The point Jeff's making is a lot of the panelists are not necessarily pro brands, but they're, a lot of them come from that area of business, and meaning they represent trademark owners more than they've represented domain name owners. And just many feel that, they have a right to make a case, especially if they do have a trademark and they meet that first prong of, yes, you do have a trademark, the domain name does include your mark, or is confusingly similar because it's a misspelling or so on. They feel like then they do have a right to proceed, and if they lose, that's one thing, but they're not really abusing the system, which we know that a company can abuse the system by saying, hey, this company has my trademark in its domain name, but like we've said before, if the domain name was registered well prior to the registration of the trademark, and if it's a generic trademark. While we're on sort of this topic, I wanted to ask both of you, both the lawyers. Okay, someone someone has a domain name like, or they're a company, Purple Mattress. Okay, so in there, I know there is a company that does that, but say uh, they go by Purple. They're a mattress company, and then someone registers Purple, I don't know, Purple Bedding, or just Purple in another extension. But the first thing they do is contact, let's just say they register purple.tech if it was available. And the first thing they do is contact Purple Mattress, Purple, they're on purple.com, and say, we have this name, we want to sell it to you for $1 million. You guys are eventually going to have, use more technology in your mattresses and so on. We know this is the right name for you. Okay, so those are some of the facts to the case. Now, even though purple.tech and purple is a generic, term, let's say, or, it's just a color, if the complainant if Purple Mattress decided to file a complaint in this case, even though purple is a generic word, could they still win because of the domain owner showed that they know of the trademark owner and they've targeted them? And I mean, can a complainant still win even if it's a generic term?
Short answer is yes. They can win, right? If there's no there's no intention to use it, um, in its generic sense, and the only thing you're doing is deliberately attempting to sell it to the trademark owner, then yeah, that's bad faith. Um, you don't consider all the other hypotheticals. Well, it could be used for a generic purpose. Um, you have to, put your money where your mouth is and show that you're either marketing it as for its generic purpose, or that you've reached out to everyone in the world to register this. So just because you have something that's truly generic doesn't mean that you automatically win a UDRP.
So Purple Mattress Company bought Purple.com for 900,000 about 5 or 6 years ago. So,
All right.
that was an upgrade. So I don't know how that happened. Was it an inbound? Was it an outbound? How would you do a deal like that, where you have the singular version of the domain? Are you representing the singular version of their brand?
Well, my guess is that Purple, the mattress company, hired someone to go in and get the name and for the best price. And I don't know if Purple was a brand that people had heard of at that point. Um, but if they were, then yeah, they probably did it through an intermediary. And that's the way most brands do it now. If they want a particular name because they're going to offer a certain product line, a company like Amazon, Microsoft, frankly, any large company is not going to approach the domain owner themselves because they're afraid of getting an artificially high price.
Let me make a point. So, David, you make set up a good scenario there. What I think what is fair, what somebody would do if they owned Purple.com and they wanted to sell it to Purple Mattress and they were aware of them, they say, you know, we've owned Purple.com. This is if they did in fact own it prior to the trademark. If they didn't, if they did own it and say we've owned this a long time, we think purple's a great color too. There's more than 3,000 companies that have purple in their name, in their trademark, and we believe any of them would be great fit for this, including your company. So you go about it that way, and then you can outbound to them. So if your intent is not just to target them, and David, I know you know this, I'm just saying for the crowd, is if when you don't have when your intention is not targeting one specific company, then of course that's how you outbound and say this potential name is, and even if you acquired it after their trademark, a company that you're getting in touch with, because there's going to be some companies that were named Purple before domains existed. Okay, Purple Design or whatever, Purple People Eater. I don't know. I know there's companies that were around with Purple in their domain name, or I mean in their company name, in their trademark before domains existed. So then what you would do is say there's a lot of different users for this. The point I was bringing that up is because I know many times people will, it really comes down to intent, like in most lawsuits. What was the intention when the person registered this name? Even if it's a super generic name, a very descriptive name, okay, it could be total, like I said, generic or descriptive. But if you bought it because you had talked with a company and you targeted that company, and then you made an effort, you showed that you're really, setting yourself up for, to be a loser in a UDRP. Now, usually there's a lot more facts to individual cases, but I just bring it up because I know you can lose a name that's generic or descriptive in a UDRP if you take actions that put you in bad light or show that you were targeting the complainant's mark. All right, there was another case.
35% of all domain transfers are generic or descriptive terms.
I did not know that. That's my Johnny Carson. That's my Dana Carvey impression of Johnny Carson. I did not know that. Okay, Walt, the next piece of news we were going to touch on was another case, Water Timer. So this is what we're seeing more and more. This was the Colombian company who this guy, they're on watertimer.co, and they filed a complaint against this. I think it was it a company out of, I don't know where the domain owner was out of, but maybe the U.S. But anyway, both the complainant and respondent in this case were self-represented. I thought that's interesting because in our first case, too, eveli.com that we're going to get to, both the complainant and respondent were self-represented as well, and we're really seeing this more and more. I can't imagine it slowing up either. But so, and I think it's fair. Then at least you have, I think as a panelist, Jeff, you would know, all right, so this person, maybe they're experienced with filing complaints, maybe they're not. This person may be experienced filing responses or not. But lawyers get so smart, in fact, that they can really add things in. Basically, they can provide you with defenses and, I guess part of complaints that can obviously strengthen or weaken a case. And usually when it comes to just people self-representing, I'd look at it as more of just them, spilling the beans on themselves and providing, just the facts. And it's easier, I believe, for a panelist to be able to sort through if there is say a thorough self-represented response on both sides. I'm just talking bullshit now. Okay, so Water Timer was a UDRP that the complaint was denied, and there was RD&H ruled because the panelists found that, hey, this complainant offered, like they normally do, they offer $500 for a domain name. They were upset that the respondent denied it, and we've all been there where somebody owns a mark and they think 500, that'll get their attention. And we know, no, 500's no, not interested. It was a complaint denied. But Water Timer, such a generic phrase in the water business, seems to be a right decision. But by the way, the respondent bought the name for $4,120, so no wonder he didn't want $500 for it. But after reading this article and knowing a tiny bit about this case, do you have any comments, either one of you?
Yeah, well, the landing page at watertimer.co is like a one-pager with product, pre-order now, enter your email address. There's no indication of what the product is. They have changing video in the background of a lady in the shower, kids in the bathtub, people out in nature, in the waterfalls, and every drop counts is their thing. So like, I don't know. Are they selling water timers for the garden, or are they selling something for the shower? I don't know. But their strategy is just to apply for a trademark and, oh, I can't get the domain for the price I want. I'm going to file UDRP. Well, that's not how it works. But apparently some people win, so they try their luck. What do you think, Jeff? Should that be outlawed?
Well, how you outlawed prevent people from filing, but I think the right thing happened here, where even though the party was unrepresented, there was still even though the complainant was unrepresented, there was still a finding of RD&H, which was right. But yeah, unfortunately, we just can't stop bad complaints. And so, it's not the perfect solution, but, hopefully, I don't even know what to say, right? Because that's one of the reforms that may be considered moving forward. In fact, comments are due pretty soon to the WIPO ICA report on what issues should be looked at for the next for the review of UDRP. I'll get the exact date, but I think it may actually even be today.
I think it's Friday.
It's pretty soon.
I think it's Friday, Jeff. I think it's the 27th.
Friday? Good.
Yeah.
Okay, cool. Yeah, so if you are thinking about that, make sure you get some comments in by the 27th. But for now, RD&H is the most we can do to punish, I guess, and I use that word lightly, complainants that file when they don't have a shot, given, especially in cases like this one, where the trademark was registered after the domain name was registered, or not even registered, because I think the domain was registered in 2001, but it was acquired by this particular respondent in 2003, which was still before the trademark was um, applied for and gotten.
Copying the link right now. It is until Friday. I'm going to copy the link and you can check it out on our outline, dnlshow.com/outline. This is if you want to know what are some of the reforms that are proposed to the UDRP. And then it also gives you a link. And I'll put it right, like I said, right on our outline underneath the it'll make it B5 on our outline. Right now we have 4 pieces of industry news, so I'll make it B5 here in just a second. I know very few may want to see it, but it gives you an idea of what the ICA was working on, what Zach was working on with regards to UDRP reform, different proposals, different ideas to improve the UDRP, if, at least according to what we believe would be improve it. And I'm saying from the domain investor side. And then they're still taking comments up until Friday. So I'll put that on there. It'll be B5 on our outline in just a second. The final thing I wanted to mention before we talk about our stories was also, if you visit our outline, dnlshow.com/outline, you'll see the B4 is second annual Levine lecture. It's coming up less than a month, July 21st at noon Eastern, so it's 9 on the West Coast. Featured speaker David Bernstein. So Zach's going to make some comments. I believe, I don't know if Brian Beckham was going to as well. I don't think so. I know it's Gerald Levine's, annual lecture. So he's certainly going to say something. But David Bernstein, well-known panelist, well-known attorney in the domain space for a long time. Jeff, quickly while I put that up on our outline, is David Bernstein, was he more of a brand attorney before he became a panelist, or what do you know about David Bernstein's background?
Oh yeah, he's definitely a law firm trademark attorney, still is. Very smart guy. He's created a lot of the UDRP jurisprudence, both both good and not so good. But yeah, he's been well known in the trademark community. I'm just looking up to see. He chairs the IP group, the IP litigation group at a large firm called Debevoise and Plimpton. He's really done a lot of high-level IP cases, not just, or trademark cases, not just UDRPs. Like he represented Twitter in their X dispute. He's represented Nike. So he's Grubhub. He's got some pretty major clients. Kate Spade. He's someone people turn to.
Okay, I got that link up if you want to check out anything about UDRP reform. And also that link that we were just talking about, David Bernstein is going to give a webinar. Zach's going to be there. It's the Levine annual lecture. So check that out. You can find both of these links at the internetcommerce.org site, internetcommerce.org. But I have the direct links. You got to go through their UDRP page and find it, so it's a little easier. Just check out dnlshow.com/outline and you'll see B4 and B5 on the outline. Make it easy for you. And we'll get to our cases now. There was one other thing. I saw a UDRP decision that just came in, MIT.mortgage. And the school, MIT, Massachusetts
Institute
of Technology. Sorry, I don't even smoke anymore. But okay, so MIT wins this case, and the guy said no, he was doing mortgage Institute of Technology, or he was doing something, but he was trying to be clear that he wasn't trying to confuse. It was a more MIT.mortgage. And to me, when you have initials, I don't care if it's NBA.mortgage. These are just great letters, and of course IBM.mortgage. If you are targeting is one thing, but it can be an acronym for so many things. So they're obviously, I mean, the guy responded, it just wasn't a great response. But when I don't know, MIT.mortgage, and the guy wasn't trying to confuse them at all. Of course, he's heard of MIT before, but any thoughts when I just bring that up? Do you just think it was a bad response? Because there's certainly defenses to owning this, right, guys?
Yeah, I mean, I'd have to read it to see what they were doing, and whether that was just kind of a made up, non-credible excuse, mortgage, whatever, um, or whether this person was really in the mortgage business and had those initials and badly defended themselves. Without seeing it, don't know, but yeah, I mean, if there was no targeting or anything like that, then there should be other entities that have a right to use those initials. Like MLS, for example, is if there was MLS.mortgage, everyone knows that MLS stands, not everyone knows, Major League Soccer, right? They're a pretty big brand, but it also is the multiple listing service, which clearly relates to real estate and helping people get mortgages. So, there are abbreviations in a lot of different fields that, MLB is another one, right? There was, you have Major League Baseball, but there's a well-known law firm that goes to Morgan, Lewis, and Bacchius that also had MLB. I think they were the ones that had MLB.com first, the law firm, and then ended up giving it to the Major League Baseball in some kind of deal. I don't know. But yeah, so no matter how famous initials are, in theory, they could have other uses. But if you're going to bank on that, in other words, if you're gonna get three letters because you think they're cool, if they match a well-known brand, you gotta really go about using it the right way or in a very careful way, because it is also very easy to get caught up in a UDRP and found to be trading off their goodwill.
I don't know if you had any comment, David, but I just hate it when they say, as a domain investor, we don't use them. We just get them because we know there is opportunity for somebody to use this in a legal fashion. And this guy said he exhausted, or he tried to, um, what did he say? He went to extreme lengths to ensure that the domain name not be confusingly similar. I think what I'll do is add this to our outline of next week, because he said, yeah, he tried to incorporate this name, Mortgage Information Technology. If this gentleman didn't answer, I'd still say then if there was no real evidence of him, trying to confuse, if MIT didn't have real evidence, even without a response, this probably shouldn't have been, should not have been a transfer. But seeing this guy did respond, and he did try to say, I'm in the business, and I have other email address. Anyway, we'll touch on it next week, because I think it's worth looking at. Like you said, MLB was owned by a law firm, and they did sell it to Major League Baseball, so it's only normal for great letters to have many uses. Go ahead, Dave.
Yeah, so MIT is registered in 292 TLDs that are active, 198 active websites from .com, .de, .net, .top, .info, .nl. There are just so many different variations. So .vision, like where does it stop? .prof. Okay, maybe that's affiliated with a school, but the rest, I can't say. And the school has a .edu, so there's no confusion there. Everybody knows that schools are .edu.
I can see if you have MIT.tech, and then they're saying that's just too close, but still I think you'd have a right to that. But I've always felt, like with Jeff's comment, that if you get something that's initials of a well-known trademark, you really need to come in there and show them, yes, I know, of course it was IBM, but I wanted to show, here's what actions I've taken to avoid confusion. Here's what actions I've taken to also, do some legitimate business that's not infringing on their market, that's in another category. I want to, here's the efforts I've made. Well, you got to show all this stuff. Basically, as a domain investor, we're thinking, listen, there's all I need to know is there are legal uses for this name. Why do I have to go forward with them? I'm a domain investor. I have this name to sell it, not to the mark owner, but to anybody else that uses it legally. And there's many different legal ways. That's why when you're owning somebody's name, Bruce Springsteen or Andy Warhol, it's limited the use and you can't infringe on those marks. But there are legal ways you can own somebody else's trademark, fair use, we talk about it, and so on, or a non-commercial use. So to me, there's automatically with any domain name a potential legal usage to it. Any name, I would say, there's potential legal use to it as long as you've made no move in any direction from the start other than just registering the name. So you just keep your mouth shut, even if it's after they've just completed their, they just got their trademark registered through USPTO and you registered the name a week later. There's still legal avenues for someone to use that domain name, you or someone, a potential, another owner, potential buyer. That's especially if you've made no moves about it. And of course, they can't show your intention was to benefit off their mark. So it's like just domain owners, you got to answer, and then you got to be careful in your answer when it's always upset me. All right. EVELI.com is our first case we're reviewing today. It's a 5-letter EVELI.com. And, when I first saw the name, I thought, I hope Evel Knievel is back from the dead and he's the complainant in this case. Anyway, I looked at it, I was like, Evely, cool, brandable. Now I see, after reviewing the case, that this complainant, Menjia out of Thailand versus Zhu Zongwen out of China, this complainant sells jewelry online. They've always went by the name Eve Lee. It's like their nickname because their actual name is Menjia. But they've had a trademark only for the last year, since really October 2024. But this complainant says, I've used EVELI, Evely, as my nickname since 2005, and I can prove it. Here's an email that I sent in 2005 when I was, applying for I was going to school for gemology or whatever they were doing. And you can see my email was EVEDANDAN at Hotmail. So I just bring that up because that was a piece of the evidence trying to show, that was submitted by the complainant, trying to show, look, I've been using this name forever. First of all, it didn't have LI in it, which was the person's last name. And this email address is not nearly enough information to show you have some kind of common law rights or, so on. But that was part of the case here that the complainant made, saying, the reason they went back to 2005 is because this domain name was registered by the respondent in 2005. And the respondent said, that's just a common nickname, especially over here in Asia, Evely, because anyway, the complainant, by the way, is on eveli.co.uk. So you can see why they wanted the .com. And I've always said this since we started this room. When you see a domain name that's in .com, that's the disputed domain name, like this, eveli.com, you wonder, what is the complainant using right now? And they're using that exact SLD, but on the .co.uk. You can understand they probably wanted this for quite a while. There's a lot of facts to this case. I'll first go to which one of you guys wants to add a little
Well,
bit?
here's an
Good.
interesting fact. There are 104 million people around the world with the last name Lee, L-I. 104 million. I'm sure there's quite a few of them going by with the nickname Eve Lee. So it's not unique. And this was a domain investor. It had a for sale landing page in 2017 before, and then recently changed it to something else, to a corporate login. And that was one of the complainants' beefs. Like, oh, negotiations broke down, so the respondent changed their landing page to this corporate email login thing.
Yeah, when I read this, I thought it was like a brandable name like Everly, which I thought was kind of cool too. So I would, it wasn't until I started reading down, um, obviously that because the complainant was saying, "Oh, I go by Eve Lee." That was the first time I kind of looked at it. Went, "Okay, so it's not Everly." Um, but look, I think the case came out right. There was definitely, first of all, she's got a trademark, but the trademark was 2024, way after the domain name was registered. And although she claims that she used the name back in 2005, there wasn't much that, one email is not, enough evidence, especially because proving rights in a personal name is, difficult. And if you're trying to argue that, yeah, I know I didn't get the trademark registration until 2024, but I had common law rights in it, it's that much harder to establish your right to uh, your rights back to that date. And even if she could have established her rights back to that date, there was common law rights are very um, geographic dependent. In other words, it's not like worldwide protection just because you have common law rights. Same thing is true, obviously, if you don't have if you even if you have a national registration, it only really is applicable to that country. You really need to show that the respondent somehow would have heard of you, um, or that you were so famous that they could not have not known about you. And so none of those things were found in this case. And as David said, this really was, a person who was just not happy with the negotiation for the name, and it was a classic Plan B found to be RDNH, and so I think that was, the right result and pretty straightforward.
Yeah, one thing the panelists brought up in this case, and Jeff, I agree with you. When I first saw it, I thought cool brandable Evely, spelled EVELI.com. And then, of course, you see both parties are saying, that's my nickname, Eve Lee. And the interesting thing, both the complainant and the respondent were self-represented here. The complainant made a mistake. The panelist says maybe it wasn't a big mistake, but it was a mistake. And that was the panelist mentioned that they had threatened. They didn't like to use the word threaten, but the complainant didn't know how to word their complaint and said, admitted to threatening, saying, okay, we were on WeChat going back and forth. They got to 4,800. I don't know. Once the negotiations stopped at 4,800, it sounds to me like that's the complainant went up to 4,800 and said, listen, if you don't sell it to me, I'm going to threaten legal action. I'll maybe file a UDRP, said a few things. And then that's when the respondent said, I'm not dealing with you anymore, changed the landing page to whatever they wanted to change it to. They changed it to like, hey, we're a company, named Eve Lee then. And then that really concerned the complainant. So the complainant went forward with their threat and filed this. And anyway, the single member panelist, David Kreider, said, not only am I going to deny the complaint, but I am going to rule RDNH because of this was a plan B. You couldn't come to an agreement on the name. It's not, you don't have rights to the name. You might be doing business now. You might have a trademark as Eve Lee, but this domain was registered way before that. They have rights to the domain name, and you didn't come to an agreement, when you were negotiating. So you filed a UDRP, you threatened to, you did it, and this is a plan B. So, I think I like that the panelist, went through with the whole decision. Of course, complaint denied, but then just said, hey, this is also a RDNH, like we learned in the other, what we learned in Jerry's case from earlier, the ignis.com, that not always do panelists, they'll look at it and think, this complainant didn't have a very good case, but it wasn't, abusing the system. They had a right to come in here, and it's definitely a fine line on what some panelists believe is RDNH and what others don't. So that case was a complaint denied, RDNH, eveli.com. I'm going to try to get through our next two cases. I think we can get through them pretty quickly. This next one is Gates Honda, GATESHONDA.com. I included this case because I thought I could see. I didn't know the facts when I saw the case. I just saw GatesHonda.com. The domain was registered in 2015, and I thought this is probably a case of, fair use somehow. And then I looked at the facts of the case, and that wasn't the case. So America Honda Motor Company, the big company, was the complainant. The respondent was Jack Auld, A-U-L-D. He owns, it said Gates Honda, okay, when in fact, I don't know why Gates Honda, unless that was just part of the domain name. I don't know why that was under the respondent name, because his actual website is Gates GMC /Nissan. He sells GMC and Nissan products, not Honda. And he didn't reply in this case. So I'll throw it to, hey, Jeff, well, why don't you take it first, and then David can finish it up. Tell us a little bit about this GatesHonda.com, Honda versus this individual.
Yeah, so I read this and I was a little disappointed. Um, well, first I'm disappointed that the respondent didn't respond, but second, more disappointing was the fact that I like Charles, who's the panelist. He just looked at the evidence that was presented by the complainant, um, and did not do any of his own research to go to the website. If he had done that, he would have seen that the evidence presented by the complainant was very misleading. That although, I should take a step back. So the panelists found, essentially by looking at the evidence that was presented and not doing his own research, the complainant said, look, he's offering this Greg's Honda. They don't have a right to it. They're not affiliated with us. They don't have a license from us. And look, they're offering Nissan cars and some other type of non-Honda cars on their site, and offered them screenshots. But those screenshots were, in my view, misleading. That, yes, they were, if you go to the site, it's a real business. It's a real Honda dealership. Um, on their main site, they which it forwarded to gregshonda.net, I think. They offer only Honda cars, with the exception of this car dealership does offer for sale pre-owned cars. And it's only in the pre-owned cars do you see the listings for other types of cars that are not Honda. So if you did a proper Oki data analysis on there, yes, in the one category for Oki data, just for those that don't remember, is a case that says that you can have fair use of a trademark in your domain name if certain criteria is met. whether or not you're authorized or not as a reseller, repairer, or whatever for that brand. If you can show first and foremost that you're only offering the trademark goods for sale. I'll come back to that one. If it's clear from the site that you're not claiming or passing yourself off as the trademark owner, which normally would be through a disclaimer or something, and you haven't essentially cornered the market of these domains. So I think this was a lot closer, or should have been a lot closer of a case. I think that this could shut down, or the decision, which was in the complainant's favor, unfortunately, would shut down this Honda business. Um, that said, I think that it would be a close call from a true trademark litigation standpoint, but I think it should have been able to go there. In other words, I think that the panelists should have, if they looked at the site, should have balanced the equities and basically said, look, this may be a legitimate complex trademark infringement case, but it's not cyber squatting, um, and therefore I, as a panelist, would likely have denied it. But Charles doesn't do, he'll tell you he doesn't generally do research. He looks at the pleadings on their face. Looks at the complaint on its face. And if the respondent doesn't respond, then, too bad for the respondent. Although I just think he's got an obligation to go to the site to look to see if the complainant properly uh, represented what the site and how it's being used. And I don't think the complainant did that in this case.
Yeah, I think this case is egregious for a couple of reasons. That's one of them. And the other one is that the respondent did respond, but it was late and didn't have the following paragraph at the end of his response. The respondent certifies that the information contained in the response is the best the respondent's knowledge, and complete and accurate, and so on. You have to put this whole thing there and sign. And it was late, and why? Well, because it went to postmaster at gateshonda.com, and I don't normally look at that email address because or I went to a catch-all folder and it was buried with 1,000 other emails that were mostly spam. So how, those are good reasons to, say why it's late, but he didn't say why it was late. He didn't put this paragraph in there. And the other problem with this case is that the complainant's lawyer is based in California. And under the State Bar of California rules, lawyers have a duty of candor to tribunals. And they have to put in all the evidence, good or bad, and the case law that's good or bad, even if it's ex parte or not. But in this case, it turned out to be ex parte, so they had an additional duty to correct the record, but they didn't. So I think this decision outlines enough reasons to file a complaint with the State Bar of California against the complainant's lawyer. Obviously, they're not monopolizing the name Honda because it's preceded by the word Gates. And the respondent personal name, Jack Alt, he's just a systems manager at this Honda dealership, actually automotive dealership called Gates Automotive Group. And by the way, their domain name just got hijacked. I went there and it's got some sort of wild ads and somebody hijacked them recently. So I guess they're not really managing their websites very well. In this case, what I would have done, if I was in charge or if I was advising them, I would say, hey, you know what? You have Gates Honda, Gates GM, Gates Nissan, have separate landing pages for each of these domain names that emphasize the model cars, the make of the car that you're actually advertising. It's in the domain name. But they didn't do that.
And most of the site did that. In fact, even the certified pre-owned were only Hondas. The one section, which again is not on the front page, and you'd have to go through all the different little sections to see this one section on pre-owned cars, not certified, but just general pre-owned cars, which are essentially people just dropping it off, and they do trade-ins and stuff like that. Um, that had these non-Honda cars, and it's such a small part of the site that would not, to me, have completely nullified all the OP data factors. But as you said, the complainant didn't put in all that information, and the panelists didn't look at it. I don't know what the response said, right? We don't know what the response said. All we know is that he didn't accept it because it was not didn't contain the language and it was late.
Yeah, right, I see it. Didn't respond. You need to clarify some things for me, Jeff. I go to gateshonda.com, and only thing I see is it forwards to their, you know, the Gates. I'm sorry, it forwards to gatesgmcnissan.com/home. So I don't even see where they are. I see a gateshonda.net. That's a Honda dealership under the name Gates Honda in Kentucky, but the one in Connecticut, I don't see that where they offer the Hondas. You said so to me. I thought Charlie made the right decision. Of course, you mentioned Charlie does exactly that. He takes in the evidence, looks at that, and if it's enough, he doesn't do much research. He's only, what is the evidence? Many times he won't even listen to the complaint. He says this, he's self-admitted. He's like, I look at the evidence. A lot of the claims they make, if it's not supported by evidence, he'll throw that out. But Jeff, where do you see Gates that they sell Hondas when you go to gateshonda.com?
Yeah, the first time when I went through Safari, I got to gateshonda.com, or it forwarded to gateshonda.net.
It did. And
But
maybe
it
it
doesn't.
automatically populated gateshonda.net and you didn't see it.
I guess that's possible.
So the
All right,
point
so
is, I
if you
think,
go to gatesgmcnissan.com, or just go to gateshonda.com, it forwards to gatesgmcnissan.com. Then you click for Nissan, and then you search for models, and you see you have an option for make, and you just type in or click the Honda option, and it'll show you all the Hondas they have for sale. Last night they only had one,
okay, so anyway,
so it's not a big Honda dealer.
well, it's not, it's not a big Honda. So bottom line is they have a case there that they're not selling just Hondas. I mean, bottom line is I can see Charlie's decision in this. Of course, doing some research, and it would be difficult. He was going to have to go through and look, click on different cars. And first of all, first and foremost, it does show that the GMC and the Nissan is the primary part of the dealership. So, Jeff, I think you were looking at a totally different, GatesHonda.net. If they wouldn't have filed, Honda wouldn't
That
have
could
filed
be.
a UDRP against them because they actually, right, have a real Honda dealership. I think this guy that registered this name in 2015 basically just, I don't know, he needed to answer because he might have picked this up to say, we didn't want the confusion with the .net because people, we're also Gates Automotive and we sell Hondas. So we might have said we weren't certainly not trying to confuse ourselves with Honda, but we wanted to make sure that we didn't lose traffic to this .net. You come up with some bullshit answer, but I mean anyway. So Gates.
Maybe it automatically populated when I went through my iPhone. That's how I initially did it.
Jeff,
But
could you imagine? Could you
damn
imagine
it!
if you're the panelist and you're like, I'm going to do my research, and then that happens, and you come up with all that stuff that you said, and it's not
Yeah,
even.
damn, that would be.
I mean,
Well, no, I
would have
I
slowed it
would
down. I know, and
obviously. Yeah.
look at. I mean, this is on. We're doing this like shooting from the hip, right? We're looking, because right, you slow it down, you realize, okay, as you go to the site a couple different times, different browsers, but it's funny. Brad brings this up a lot that these auto-populating terms, and they'll do it. They automatically do it. So that in that case, it just sends you to. Sometimes you put something in it, sends you to another website, and you think, well, that's weird or that's not possible. Yeah, it certainly is. But okay, so in this case, it was a transfer. GatesHonda.com was transferred because the panelist felt that this guy registered this name to confuse people, basically to redirect traffic to his site where he wasn't really using it in a fair use way. Fair use way would be solely offering Honda products, and then you can use somebody else's mark if it's descriptive of what you do. But in this case, he was selling other products, and he just, simply, the panelist said he's not passing off as the complainant, but he's using the complainant's trademark to attract internet traffic. That's how he, made the decision, and just felt that, uh, he had knowledge of the complainant, and he targeted their trademark by doing exactly this. So that was a transfer. We got to move on so we can get out of here. We got things to do. This last case was weird. I guess it was an ADR case. They mention it, but when you look through the response, it's a UDRP. So ADR is what's it say? Something dispute resolution. What does the A stand for?
When you say ADR, it was with CIDRIP, wasn't it?
Yeah. Is that so? Are all CIDRA cases ADR? What's the A stand for? It's real easy.
Alternative dispute resolution.
Okay.
Yeah.
So this domain name was Weedverse, WEEDVERSE.com. And I apologize. We do this. I do this for 5 years, and it's like I still don't know some acronym, and it's like supposed to be not an expert in it, but knowledgeable. I just forgive me. Okay. So anyway, Weedverse.com is the domain name. Spelled how it sounds. It was registered in 2018. This is two individuals. One guy's out of Illinois, the other person out of Nigeria. And I say the complainant's out of Illinois, the domain owner in Nigeria. The disputed domain name resolves to an ATOM, ATOM, a ATOM web page. The complainant was saying that the disputed domain name was only acquired for resale. It was never been used for anything, and the person bought it simply to resell it, which, okay, so I don't know, it could be a fact, but what's wrong with that? The respondent said, they registered the name well before the complainant first used their trademark in commerce, and there's no evidence that he had any knowledge of the complainant. He says he didn't, and good news is the panelist said, yeah, there's no evidence that the respondent acquired the name to profit from or exploit the complainant's trademark. So the complainant just made some, allegations, but really couldn't back them up. And the respondent looked like the answer, I don't say the answer was thin. They responded, but it was just like you think. Yeah, that you bought it to target us. And then he responded back, no, I didn't. I didn't even know about you. And the panelist, who was Dr. Gustavo Moser, single member panelist, ruled he denied the complaint, but didn't rule an RDNH in this case. So I've given everything away. And one last thing I'll say is the disputed domain name was priced between like $599 and $19,988. So this guy bought the name. It was weedverse.com, had it for sale, moved the price around, felt like he was allowed to do that. And the panelists agreed with him. He bought the name for sale. It was before, you bought the name, you put it up for sale. It was, you registered it before this trademark. So, it seemed to me like a potential for an RDNH. But what comments do you have? Let's throw it out there, either one.
It's a long decision. That was my first comment, is that, man, they are, almost all of it is procedural descriptions, and then a very lengthy discussion of this party said this, and that party said that, and then this person came back and said this, and by the time they got to the actual merits of the discussion, that's like, what, 2 pages? 3 pages? So the whole decision is like almost 19 pages. But it isn't, but if you look at the meat of the decision, of, like analyzing the factors, that starts on page 15 and ends on page 8 or 17. And then they go into whether there's been an abuse, whether there's RD&H. The first 14 pages are all procedural and description of who said what, and almost fell asleep during this reading this. But that said,
page 11 is pretty important.
let me see, hold on, page 11. See, now I'm scrolling through 8, 9, 10, 11. Well, sure, but it's again, the analysis is on. I like to read the analysis more so than and go back to the facts. But yeah, so the facts in this case are not just that he registered it way before, not way before, but registered it before this trademark came into existence. But the domain name was consistent with a couple different naming conventions that this investor uses. One is in the cannabis industry itself. So this investor's registered a pattern of cannabis domains, but also registered a, has a history of registering names that end in verse, VERSE, and so that's yet another credible reason of why, um, you know, or gives the respondent credibility as to yes, this person is really a domain investor.
So from what I gather there, the domain was registered in 2018, but he acquired it in 2024. Let's see what page that is on. Yeah, so he got through a SAV auction on December 24th, 2024. So he wasn't the original owner. He just picked it up. And so his defense was really useful in that respect. It wasn't that he just registered the domain and owned it before the trademarks. No, it was the opposite. He got the name after the trademarks were in existence. He just says he didn't know about them. But it was part of his investing practice of getting domains that ended in the word verse. And he listed off a whole bunch of them, including Rotaverse and what was the rest? Frostverse, Radarverse, Fusionverse, Cogverse. Like none of these names make any sense to me. But anyway, I think Weedverse might be his most valuable name out of that list. And the cryptoweed.studio website it's a start, but it's nothing substantial. This guy he's just got a bunch of trademarks and he's trying to do something, but he doesn't have the right branding. He hasn't built it out. He doesn't really have trademark rights to the extent that you'd expect.
Well, you made a good point, David, and we're going to wrap this up. And Jeff, I'll reach out to you in about 10 minutes about our call because I got to make a call in the meantime. I had to tell him in front of everybody. But David, you made a good point here. This domain was acquired after the trademark owner had his trademark rights, but still, what you would do in this case, the respondent answered appropriately, saying, hopefully they said under penalty of perjury, I didn't know about this trademark owner. And of course, you only want to do that if you really didn't know about him. But many times when you register or you acquire a brandable name, you don't know of all the different brandable owners. And even if you did do some research after you bought your name and then you see it, you can still say under penalty of perjury, I didn't know about it when I acquired the name. You may have known about it an hour after or a week later, but many times with like Weedverse, you might think, geez, I could, that's why sometimes it's good not to search, meaning you could think this could be a great name. I don't suspect that I'm the only person that's ever thought of putting two words together like this, or Weedzilla. I think I own Weedometer. The point is, if you don't know of a trademark owner at the time you acquired the name, very important to list that out, especially you acquired it recently. So everybody that acquires names in the last couple years, likely if there is a trademark owner, they may have had it, prior to you getting the name. So that's number one, stating firmly and, under penalty of perjury, to say, I didn't know about the trademark owner. And secondly, if you are a domain investor and you have similar names, of course you want to put that. I know my partner is in a UDRP right now. We're waiting for the decision. Under KSuite, SUITE.com was the domain name. He's registered over 100 other names with something before the word suite. If you have that, you certainly want to include that in your response. It showed to be successful, help success in this case. And if you don't have those types of names that are similar to the disputed domain, at least if you're a domain investor, you might want to, show names that, other brandables, even if they don't include the word verse or something like that. So this person did. Okay, I'm only because Nathan was here earlier, but I got to go. Okay, so that's it for today. This was a complaint denied, no RDNH. We're going to give Nathan the last word, then we're going to shut her down for today. What's up, Nathan?
I just wanted to thank Jeff in reference to representing one of my clients in a court matter in the US. That was a really, really good result. And I'm glad that, I was able to refer him to Jeff and they get a great result.
Yeah, thank you for the referral. Yeah, it was. I mean, we did talk about that case after it was filed because once it's filed, it's public. And yeah, it was the case where this was the case that for those of you who remember where it was reported on Domain Name Wire too that the seller had actually backed out after it found out who the buyer was. Ultimately, at the end of the day, we got an injunction, and that ended up settling, and the right party has the name now. So yeah, it was a good case and saved a lot of money for your client who was initially approached by other law firms that quoted a huge amount.
Yeah, that was the one with pay in it, PAY, somewhere that I remember
Yeah,
the
pay
case.
rewards.
Yeah, pay rewards. Very good. And thanks, Nathan, for jumping up here again and, on Jeff's behalf, referring him. No, Jeff is, qualified to handle different aspects of cases, whether it's something like this, simply trying to step in and get a settlement. Jeff, we don't need to hear about what you're going to Arizona for. We'll talk about that next week. You might have some information for us. It is a domain dispute case. Is that what you're heading to AZ for?
We'll talk about it next week.
Okay, maybe. All right. Hey, yeah, he's got to handle it first. All right, everybody. We really appreciate you stopping and joining us. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. This is the Domain Name Law Show. And then on Thursdays, I do a show with Josh Reason. It's called the DNX Show. It's about domain investing. And we're on for 10 a.m. Pacific, 1 p.m. Eastern this coming Thursday. Josh is in the UK with family, visiting family, traveling with family. So Arif is going to be joining me, really is to move the conversation along. Josh just posted, I'm going to be there. He's still going to be there. It's only 6 p.m., for him. So over there in the UK, but we're letting him relax. It's not stressed about having to show up, but he's going to be there anyway. So join me and Arif and Josh this Thursday for the DNX show, where we can talk strictly about domain investing, and we got a lot to cover. So thanks. Enjoy the rest of your day.